Can we start now?
Yep, we're broadcasting now. A few participants are joining.
Okay, dear IPBA friends, dear friends and experts who attended this webinar online, Happy New Year. This is Li Dongpan. I'm the Intellectual Property Committee Chair of IPBA. Welcome you all for the webinar. Although we have very difficult pandemic year, I hope we really have a happy year and good business in the new year. I hope that everybody will be very, very happy in the new year. This is the first IPBA webinar for this new year. I would like to briefly introduce the stages of the webinar. In the first 10 minutes, our first 10 or 5 minutes, our IPBA President Jack Lee will give an opening remark. And then I will briefly introduce the case scenario for the IP webinar. The case scenario is the basis of our whole session for the speaker's discussion. In the next stage, we will have 6 jurisdictions. There are Germany, US, Japan, Korea, China, and Brazil for discussion or patent cases scenario. Each jurisdiction may have 12 minutes for the speech. We may have last 10. Sorry, my technical problem. Then we will have last 10 or 15 minutes for the Q&A, question and answer. So let's start for the first stage. First of all, let's welcome IPB President Jack Lee give the opening remarks. Jack, please.
My dear IPBA members, brothers and sisters, dear Mr. Panidong, and distinguished speakers and guests, I thank IPBA officers for organizing this timely seminar, taking place on the devastating impact brought out by COVID-19 pandemic. I do appreciate the joint efforts and collaborations from all our members and officers working for IPBA during such a difficult time. The emerging economy, it brings more opportunities amongst different countries for goods trading and transaction, and such trends inevitably bring more possibilities for incurring the disputes. Insofar as the cross-border disputes arising out of the transnational trading, the intellectual property rights disputes and other disputes in relation to this area often one of the most complicated and profoundly significant matters for our international lawyers. Therefore, particularly at this special time that medical devices and items trading shows its explosive growth this year, the infringement disputes on invention patents will surely be a significant topic among countries and legal practices. Also, we may find out that ICEP requires members to adopt appropriate measures to prevent the abuse of intellectual property rights by rights holders or the resort to practices which unreasonably restrain trade or adversely affect the international transfer of technology. Like other regional or international law or rules, RCEP values the spirit of international cooperation and strong and effective protection to our intellectual property rights. Today, the IPBA's Intellectual Property Committee is bringing you this fascinating discussion on cross-border issues pertaining to patent infringement. We will have an interesting topic and some discussions around a case set in advance, which is a German company a Chinese company and a Brazilian company are all engaged in production of certain products and are competitors to some extent. The German company claims that the products of Chinese company and the Brazilian company infringe on its invention patent and brings litigation against them in Germany, USA, Japan, and Korea. Consequently, we invited speakers from these jurisdictions to present their opinions as counsels representing the Chinese and Brazilian companies and the counterclaims or measure, if any. Ladies and gentlemen, I would like to encourage you to focus on today's topic and discussions from now on. Before closing my opening remarks, I would like to invite you to IPBA Shanghai Annual Meeting Conference on April 18 to April 21st this year, and I will sure bring you an unforgettable event in Shanghai. Thank you very much.
Thank you, Jack, and thanks again for already brief introduction of the case scenario. I just want to make up some sentence. Firstly, the case is based on assumption that the patents have been granted in all the jurisdiction based on the same technology, based on application through PCT. And then each jurisdiction will present their defense on the litigation, any countermeasures, and very important is the invalidation measures. First one, we start from the jurisdiction of Germany. Mr. Andres Wellhall, Andres, show your hands. Andre will speak on the Germany jurisdiction. Andre is a partner of Munich office of Glass Last Law Firm. He is an IP and IT law expert. He is also an expert in food and drink regulation. And he has represented many clients in IP and IT, and also in the food and drink areas for many famous cases. Andre is a great lawyer in Who's Who Legal Germany 2020, and also trademark star 2020 IP stars. He is also an expert in many areas. We leave the Germany jurisdiction to Andre. Andre, please.
Thank you very much, Lidong. I will share my screen and will start my presentation. Okay, so our scenario has been explained. Let me see, I need to do it. Okay, and I will start from the German perspective. In our hypothetical case, the German company A that has received the granted patent is bringing lawsuits against company B from China and company C from Brazil in the German jurisdiction. Okay, so and as a counsel to a B and C, I would evaluate the options and possible measures of defense. I have three. In my presentation, I have three steps. First, the defenses in the current infringement proceeding, and then the option of an invalidation action against the patent in suit and possible counterclaims. So, to start with, I just give a short overview what kinds of measures and claims could be raised by A against the infringing competitors B and C, and this could be obviously an injunction And then, of course, in Germany, it is the standard procedure to ask for a declaratory judgment on damages. That would be a judgment that simply declares that damages must be paid, but no specific amount to be specified later. And then another claim could be disclosure of trade partners who received the infringing products. So it's a claim for information, and also information disclosure of accounts and sales information. So you would seek a declaratory judgment on damages, and then you would seek the sales information in order to calculate the damages. A further claim of A could be destruction of infringing products. And finally, a claim would be possible for a recall of infringing products from the trade or from the market. A first instance judgment could be provisionally enforced against a bond of security. So you don't need to have a final judgment in the final instance. You could start enforcement earlier. That's important for the timeline. And then if we look at the first instance, at the timeline, here it depends very much to which court you go. Actually in Germany, we have 12 courts of jurisdiction. Germany is a federal system, not so centralized compared to France or Great Britain or other countries. And we have 16 federal states, and each state has its own patent court. While this is the legal situation, the practical situation, in practice, most plaintiffs go to 3 courts only, 3, and I have mentioned them. That is Düsseldorf, Mannheim, and Munich. Those courts have most of the cases, and the judges in these courts are very experienced, and they in a way they like patent law, and they are very professional in dealing with patent law. If you go to another court, it will be difficult. The judges do not have the expert knowledge and will be reluctant to handle the case. So most cases are handled in these 3 jurisdictions, and sometimes also in Hamburg. The timeline is, as noted here, 16 to 20 months in Düsseldorf, 10 months in Mannheim, and 8 to 12 months in Munich. Actually, what you find is that these 3 courts, in a way, compete between each other for the cases. They want to build their reputation and want to show that they also are, that they want to get more cases to increase their importance in the so-called market in Germany. That's really the case. Okay, let's see. So the standard timeline would be 16 months, could be 1 year. The 8 months is maybe a bit optimistic, but 1 year is absolutely possible in Germany for the first judgment. As a counsel for B and C, I would have to present all substantial defenses before the main oral hearing. Otherwise, they might be dismissed for late filing. And then, of course, as you can see, the timeline is very, very ambitious. It is actually difficult to get time extensions. Not the typical deadline would be for 2 months in a response. You can ask if there are difficulties for an extension, but it will be difficult to get. You need very good reasons, and only very short extensions can be granted. You cannot get several months extensions. That would not be accepted. Even though you're a foreign company, you have to get along with the 2 months and maybe 1 or 2 additional weeks. So what kind of defenses are possible? Of course, you could plead in the proceeding that that B and C do not infringe. First of all, no direct infringement, literal infringement. You would deny literal infringement, and then of course you always have the issue of the doctrine of equivalence, equivalent infringement. Here you have some more defenses, and it's possible to bring more arguments. And then also we have to look at indirect infringement. If you simply contribute to the infringement and B and C are not, but in our case, I think that would not be an option here. And then, we have this issue of prosecution history estoppel. That's an international concept that is available only in a very limited way in Germany. In Germany, normally the court will be reluctant to look at documents outside the actual patent. Something that happened before the grant will only be looked at in exceptional circumstances. Maybe I can explain this later. And then before we come to the issue of invalidity of the patent, there's of course a number of other defenses, for example, permitted use, private use, non-commercial use. And then, of course, the German Patent Act also provides for a prior right, prior use right as a defense. But then, of course, you would have to have really good documentation and evidence on that. Other possible defenses could be a license, of course, and then exhaustion, regional exhaustion. And finally, in the antitrust defense, in case of the standard essential patent could be raised. So you could claim, you would have to provide an offer for a license under fair use conditions. But here again, we have a new case law, and the requirements are very strict, and it's difficult to meet these requirements for standard essential patents. So let me see. Then we, of course, we have the invalidity defense. That's always an important option. And I think here, I think that's one of the most important takeaways from the German perspective. And different to other legal systems, in Germany, you cannot raise the invalidity defense in the infringement proceeding. So you cannot bring a counterclaim for declaration of nullity, of cancellation of the patent. That will not be accepted. It's not possible. Instead, Germany has the so-called bifurcation system. So you have two separate streams. One stream is the litigation for infringement, and the other separate stream is the invalidity proceeding, the nullity proceedings against the patent. And not only will it not be possible to bring it in the same court. Actually, it is a completely different court. The infringement proceeding is brought in the state courts, like Düsseldorf, like Munich, or Mannheim, while the invalidity proceeding has to be brought in the Federal Patent Court. The Federal Patent Court is a separate system based in Munich, but it's a federal court on the federal level, not on the state level. And you would have to bring the invalidity lawsuit in this Federal Patent Court unless there is an opposition already pending against the patent, of course, and opposition can be entered at the German Patent Office, the European Patent Office against the patent. But if there is no opposition, you have to bring it in. You have to bring your invalidity case in the Federal Patent Court. And then, of course, the question is, of course, then imminent. Once you have filed your invalidity action, can you get a stay of the proceedings? Let me see. Yeah. And here the first point is you have to raise this point, the invalidity, very early in the proceeding. You cannot wait until the last minute, and then suddenly, when you realize that the judge says, "Oh, there could be infringement," then suddenly you, "Oh yes, I just had the idea. I want to file an invalidity action." That's too late then. You have to do that right at the beginning. You have to raise this defense very early, and then you can ask the court for a stay, but still it is very difficult to get a stay. How's the timing for me? Shall I come to an end or?
Yeah, I think Andres, you can quickly finish the rest of the slides.
So in other words, I think that's an important thing.
세미나가 시작된다면은 접속 링크가 죽어가지고
Final thing that the nullity case, the invalidity case, goes slower, takes more time. And what happens is that you have an injunction gap. You can enforce in the infringement court while the invalidity case is pending. You get a judgment, you can enforce it, and it takes more time for the invalidity case to proceed. And that can be a substantial problem, can really create problems for the infringing party, for the defendant. And actually it is the case that this is currently in discussion in Germany, and that the legislature is looking at possible measures to change the law here. So to speed up the invalidity case, to bring it in line with the infringement case. So it is not contemplated to join it, to have one proceeding, but the two proceedings shall be coordinated and at the same speed. But I think still that if you have probably if you have a patent that is maybe could be susceptible to attacks, to nullity attacks, but you still want to enforce it, the client wants to enforce it, Germany could be a good option due to this bifurcation system. So I think I stop at here, and then we should look at the other jurisdictions. Thank you.
Thank you, Andres. Thanks a lot. You already introduced a lot of very special legal regime and special requirements under the German patent law. Now we turn to the US patent law. Speaker will be Chris Carl. Chris is a partner in, Chris, show your hands. Chris,
hello.
Hi. Chris is a partner in Pillsbury, San Francisco and Silicon Valley office. He focuses on intellectual property and complex commercial litigation. Chris represents many technology companies in many patent infringement cases in federal courts in the US and also the ITC. He's also has extensive experience for inter-parties review proceedings before PTAB. Chris also regularly advises clients on privacy and cyber security issues and is designated as certified international privacy professional US by the IAPP. Chris, please.
Thank you, Li Dong. So I'm going to be discussing the defenses that are available in patent infringement suits in the US. If in this hypothetical, the German company were to sue the Chinese company and the Brazilian companies in the US. So let me share my screen. I hope everybody can see this. So in the limited amount of time that I have, I'm going to review sort of the common defenses in a patent infringement case, the invalidity challenges that you can make in the USPTO if you are a defendant in a patent infringement litigation, counterclaims that are available, and declaratory relief if we get there. So starting off with the common defenses. Patent infringement suits in the US can be brought in federal courts. There's federal courts in every state in the United States, all 50 states, and a patent infringement suit could be brought in any one of those 50 states, subject to some of the rules that we will talk about. In addition, in the US, patent owners can file suits in the International Trade Commission, which many of you may be familiar with. The difference being that a suit in the International Trade Commission is designed to be one to prevent the importation of allegedly infringing products. And so the only relief that one could obtain from the ITC is an injunction against the importation of the products. In district court, you can both, federal district court in any of the states in the United States, you could obtain both an injunction and monetary damages. So that's the difference between those two types of forums. In terms of defenses, if that are available to the Chinese or Brazilian company, if they are sued in district court, is the example I will use here. One is service of process. Because they are foreign defendants, the United States recognizes the Hague Convention, and therefore, in order to properly serve the defendants, they must be served pursuant to the Hague Convention. And if they were not, the defendant could challenge service of process. Jurisdiction. In order for a court in the United States to have jurisdiction over a foreign company, such as a Chinese company or a Brazilian company, those companies must have engaged in conduct in the United States, and in particular in the state where this lawsuit was filed. So that means if the case was filed in Texas, for example, or California, or New York, the defendant would actually have to be doing business in that state in order to be subject to the court's jurisdiction. That means selling products to customers in that jurisdiction. You don't have to have an office there or employees there, but if you are selling products to companies or individuals in that state, you will be subject to the jurisdiction of the court. But it's a common defense for foreign companies to raise this issue if they, for example, only sell to distributors who may be located outside of the United States, and those distributors in turn sell products into the United States. The Chinese company or the Brazilian company may not be subject to the US court system. Venue. Venue can be challenged, and what that means is the state that essentially that you have been sued in appropriate? Is California the right state for you to be sued in? Here in the hypothetical, it's easy. Unfortunately, under US law, foreign companies, foreign defendants can be sued in any state in the United States. For domestic companies in the US, they can only be sued where they're incorporated or where they have an actual place of business, but foreign defendants can be sued anywhere. In terms of the substantive defense,
I found this on the web for any states in the United States.
Siri is talking to me for some reason. Sorry about that. The substantive defenses that are available are similar to, I think in any jurisdiction around the world. So I won't go through those here, but they're obviously non-infringement you can raise in the district court. Unlike in Germany, you can raise invalidity in the same court that you've been sued in. You do not have to go through a separate process. And inequitable conduct, which essentially means you can raise a defense if you believe the patent owner made misrepresentations or deceived the patent office, the United States Patent Office in some way in obtaining the asserted patent. In addition to the district court system, in the United States, you can raise challenges to the validity of the asserted patents in the United States Patent Office before the PTAB. There are three basic mechanisms for this to raise challenges in the US Patent Office. One is ex parte re-examinations. These are requests that any party can submit to the Patent Office challenging a patent. But once you make a request for an ex parte re-examination, which is sort of obvious based on the language that is used, you no longer participate. So you simply file a challenge, you submit prior art to the US Patent Office and say you believe a certain patent is invalid. The Patent Office will then continue that process with the patent owner, and you as the requester no longer get to participate. So it is of limited value, but it can be done anonymously, which may help if your client would like to make a challenge anonymously. Post-grant reviews are only available within 9 months of the patent issuing. So if you intend to bring a post-grant review, you need to do it very quickly after the patent issues. So oftentimes in litigation, the patents that are being asserted have issued years ago, and so a post-grant review is not available to you. The post-grant review, which is different from the inter partes review, which we'll talk about next, the benefit of a post-grant review is that you can use it to challenge the validity of the patent under anticipation grounds, obviousness grounds, 112 grounds, which are written description grounds, if you think the patent has not been drafted appropriately. You can rely on any available prior art. It's not limited to patents or printed publications. You can rely on systems that were sold, products that were sold in the market. You can potentially get a stay of the district court litigation pending a PGR, a post-grant review. Inter partes reviews are much more common. I would say in the United States system right now, the percentage of post-grant reviews versus inter partes reviews is probably, 2 or 3% of PGRs that are filed versus the rest of the reviews that the PTO considers are inter partes reviews. You have 1 year from the service of an infringement lawsuit against you to bring an inter partes review. However, IPRs are limited to anticipation and obviousness challenges. They are also limited to patents and printed publications. At the beginning of the program, there was almost an 80% chance that the PTO would undertake an inter partes review. That number has fallen in the last several years, in part because of the new US PTO director that was installed 3-4 years ago. The percentage chance of getting an inter partes review instituted has fallen to about 50%. So it's about a 50-50 chance these days. Generally, courts will stay the district court litigation pending IPRs, which is a big benefit to defendants in patent infringement lawsuits. But there are some exceptions. So for example, courts in Texas generally will refuse to stay the case. Courts in California and courts in Delaware, those are the 2 other states that tend to see the most patent infringement lawsuits, will generally issue a stay of the litigation. But if you're in Texas, unfortunately for defendants, you're unlikely to get a stay and you will have to proceed on dual tracks. In terms of available counterclaims to defendants in the US, there are many, many counterclaims. I will just, list the, I'm just checking here how I'm doing on time. Okay, I have 1 minute to wrap up. In terms of counterclaims, there are many. I've listed the most common ones. You can bring an antitrust counterclaim, particularly in the SEP, standard essential patent context. If the patent owner has not complied with its obligations to license the patents, for example, on FRAN terms. Patent misuse is a counterclaim that can be brought if the patent owner is trying to use the assertion of these particular patents to force you to do more than would be required by patent law, to take a license, for example, to patents that have not been asserted, or to engage in some other conduct that goes beyond the rights that are conferred by the patents itself. And of course, you can assert your own patents against the patent owner, and that's quite common in a competitor case. If a competitor brings an action against a company in the US. If the defendant has patents that the plaintiff is infringing, you can obviously file those as counterclaims. And then finally, I'll just mention, if the patent owner does not sue first and just simply threatens an action in the United States, there is an accused infringer is able to seek declaratory relief in courts in the United States and essentially bring a lawsuit first against the patent owner for a declaration that the asserted patents do not infringe or are invalid. So with that, I will stop there, and we'll be happy to answer any questions at the end of the presentations about US patent infringement cases. Thank you.
Thank you, Chris. Thank you, Chris. You're right on time. Next. Okay, I have some questions I will later ask you during the Q&A. Okay, then we have the next Japanese jurisdiction. Mr. Masayuki Yamanouchi. Masa is a partner of Anderson Mori. He holds a master's degree in science and chemistry. He has been engaged in a number of patent infringement lawsuits and other IP-related matters. His main focus is on the pharmaceutical industry in patent infringement actions, as well as licensing negotiations, joint development projects, and technology transfer projects. He is also expertise and experience in other forms of IP, including trademarks, copyrights, and trade secrets. Thank you, Masa. Please.
Thank you very much for your introduction. So I will start sharing my screen for the presentation for Japan jurisdiction. So because of the limited time, I would like to focus on only the important and the basics of countermeasures and defenses in patent infringement actions in Japan. And I also want to mention about the differences from the German system and US system, because I think it's an interesting point for the participants of this seminar. First, as you may have heard, Japan has introduced a patent system and as a civil system from Germany. So some part of the Japan system is similar to German system, but after that, we also imported some theory and systems from the US. So Japan system is a kind of a hybrid of German system and the US one. So I would mention about the similarity with the German system and the US system during my presentation. So first, possible countermeasure for defendants in patent infringement action is an non-infringement arguments. I think most of the possible non-infringement arguments are similar to other jurisdiction, similar to the most jurisdictions, defendants need to deny infringement, not only literal infringement, but also infringement under the doctrine of equivalence. So the defendants need to argue that the alleged infringement product does not have at least one element of the patent invention. And I understand that in the US, there is a separate claim construction procedure called a Markman hearing, but Japan does not introduce such a system. So district court judges do a claim construction during examining the infringement arguments. And I would explain about the invalidity defense, but I would recommend defendants making a combination of a non-infringement argument with invalidity arguments, because making invalidity arguments, defendants can force patentee, the plaintiff, to a certain claim construction narrowly in order to avoid novelty or non-obviousness arguments. So that might help defendants to make a non-infringement arguments. So the second important countermeasures or defense for defendants is an invalidity arguments. And the defendants have two venues for invalidity arguments. One is a procedure before the JPO, and one is defense, invalidity defense before the patent infringement court. So this slide talks about the procedure before the JPO. And similar to the German system, we have a kind of bifurcation system. And the defendants in a patent infringement action can commence an invalidation trial before the JPO, even after infringement action is filed. And there's two kinds of procedure to attack the validity of patent. One is a patent invalidation trial, and the other is a post-grant opposition. As you can see in the lower side, post-grant opposition can be filed only within 6 months after the publication of the patent gadget, but it can be filed anywhere. And you have to name a requester of oppositor, but he can or she can be a strawman. And compared to that opposition procedure, patent invalidation trial can be commenced anytime after the issuance of patent, but can be commenced only by a party having interest in the patent. So you need to identify or disclose your identity when filing a patent invalidation trial. And in patent invalidation trial procedure, the JPO usually holds an oral hearing, and the defendants or alleged infringer would have an opportunity to make a presentation before the JPO. Such an opposition would not usually given in a post-grant opposition course. And the patentee will have an opportunity to correct the patent claim to overcome invalidation grounds, but such a correct is only to narrow the scope of the claim. So that correction might also be helpful for the defendants to make a non-infringement arguments. And this slide talks about the invalidation defense before the infringement court. So as I mentioned, the defendant can also seek a dismissal of the patent's claim by arguing that the patent has invalidity grounds. So unlikely to the German system, the defendants have such an opportunity. And invalidity grounds can be a lack of novelty or non-obviousness, which may be sometimes called the inventive steps. And failure to meet written description requirements can be also on a basis for invalidity defense. And amendment made during the prosecution history, which introduced a new matter, would also be an invalidation grounds. So if you are a defendant in a patent infringement action in Japan, usually the novelty and non-obviousness requirement would be the most important factor for the validity of the patent. So I would recommend making a prior art search to see whether there is any grounds for the invalidity defense. And also we have a bifurcation system, the procedure before the JPO can run parallel with the infringement action before district court. So defendant can commence invalidation trial before the JPO while making an invalidation defense before the infringement court. And the Japanese court are not obliged to stay infringement action, even if the defendant commences invalidation trial before the JPO. So you may have a JPO decision before the infringement court judgment, but the vice versa can also apply. And the appeals from the JPO and the infringement court, district court, will be examined by the same panel of the IP High Court. So even if there is any discrepancy in the conclusion between the JPO and the infringement court, the IP High Court would unite and make a consistency in the conclusion. And for your information, recently, the invalidation trial ratio before the JPO is quite low. About 10 years ago, it was about 50%, but recently only 20 or 30% of patents are invalidated. So recently, I do not recommend all the defendants to commence an invalidation trial, because if the JPO issues a decision upholding the validity of the patent, it would adversely affect in the conclusion of the district court. So unless you have a good prior reference to attack the novelty of the invention, I would recommend focusing on invalidity defense before the infringement court. So I think this is the last slide of my presentation. I would like to mention about other countermeasures. First one is designing around. So as I mentioned, in order to present a non-infringement argument, you need to point out that the alleged infringing product does not have at least one element of the patent invention. So the defendant may want to design or change the design of the product to support his or her non-infringement argument. And the implementation of such a designing around would not constitute an admission of an infringement. And of course, the settlement negotiations would be one possible countermeasure to avoid an injunction, because Japanese court would issue an injunctive relief once the judge finds a validity and infringement of the patent. So the injunction is basically automatic, unlikely to the US IPBA Supreme Court judgment. So the defendants may want to have a settlement agreement with the defendant. And in Japan, Japanese judges can take a role as a mediator during the course of patent actions. So the defendants and patentees can make a settlement negotiation with help from judges. So this is the end of my presentation. Thank you very much.
Thank you, Masa. Thanks a lot. Also right on time. So we still have enough time for the rest 3 jurisdictions. The next one will be Korea. Korean jurisdiction is presented by Mr. Kwak. Mr. Kwak is a partner of Lee & Co. IP Practice Group. He has experience in the fields of IP litigation and transactions. He is an distinguished IP practitioner and registered partner attorney. Has a track record in high-profile cross-border patent and trade secrets litigation cases. Mr. Kwak earned his LLM, Master of Law degree from UPenn in the US, and completed a PhD course in IP law. Mr. Kwak worked at top-ranking US law firms in Washington, DC and New York, NYC. So he currently served as a director with the International Association of Korean Lawyers Association and a member of the Korean Intellectual Property Law Association. Thank you, Mr. Kwak. Mr. Kwak, please. Mr. Kwak, please.
Thank you. Yeah, thank you, Lee Dong, for your warm introduction. Good afternoon, everyone. I'd like to first thank everyone for taking your valuable time to watch this seminar. My name is Joe Kwak, and I'm a partner in the IP group, Lee & Co., one of the most largest law firm in Korea. So let me share my slides to you. Can everybody see my slide? Okay. So based on my knowledge and experience, I like to talk about what defendant can do in patent infringement litigation in Korea. So I will first briefly introduce patent litigation system in Korea, discuss what options defendants have during patent infringement litigation, patent invalidation trial, and finally, what counterclaim measures defendant can take. First, patent litigation system in Korea. One aspect of patent litigation in Korea is that it has adopted the dual track approach. Jurisdiction for patent infringement is in the court, while jurisdiction for patent invalidation is in intellectual property trial and appeal board, in short, IPBA, which is an agency under Korean Intellectual Property Office. For patent infringement, litigation starts at district court, which decision can be appealed to patent court, and then be appealed to the Supreme Court. Similarly, for patent invalidation, while it starts at the IPBA, the decision can be appealed to the patent court and then to the Supreme Court. So the two tracks converge at the patent court and then to the Supreme Court. Next, I'd like to talk about what options defendant has when sued for patent infringement. When accused, most of the time, defendant can and will deny plaintiff's accusations and facts. Defendant often argues that their activity does not infringe either literally or under doctrine of equivalence, in short, DOE. But defendant cannot just say they do not infringe, but must show a specific embodiment of practice. Otherwise, courts may accept plaintiff's infringement accusation as proven. So defendant should first make sure whether it is performing the activity as claimed by plaintiff, then whether that activity infringes the patent, the plaintiff's patent, to respond strategically. One option defendants has for its defense is abuse of right defense. And this means that since the asserted patent is invalid, asking injunction or damage based on that patent is abuse of right and should not be permitted. As I previously said, patent invalidation is under the jurisdiction of IPBA. However, if defendant raises this defense, then district court may hear on patent invalidity. And if found invalid, court may dismiss the suit. District court can base their decision on novelty and written description and also inventive steps. But even if district court finds patent invalid, this doesn't mean that the patent is invalidated, but just that patentee is limited from exercising its right. To use this defense, a defendant should investigate patent's validity. So if there's any reason for the patent to be invalid, should bring this defense. Another defense that defendant can utilize is called the existing technology defense. It argues that defendant's activity actually existed before the asserted patent and therefore not infringing. In other words, existing technology refers to when the activity is identical with technology publicly known before the filing date of the asserted patent or is readily derived from such technology by a person with ordinary skills of the art. This defense is useful because there is no need to determine the validity of the asserted patent or compare defendant's activity with the technology at issue. Instead, you can just compare defendant's activity to an existing technology to determine whether it falls under the scope of the asserted patent. As you can see, this is faster and more efficient. To use this defense, defendants should first research publicly known technologies before the filing date of their asserted patent, and then assess whether the findings are adequate to bring the defense. Next slide. Last option I want to talk about is right exhaustion defense. This can be useful when defendant legally obtained the patented product. Like many countries, Korea also recognizes the exhaustion doctrine. The doctrine states that if patentee, exclusive licensees, or non-exclusive licensees legally transferred patented product to defendant, then subsequent transfer or use of the product does not constitute infringement. For example, when patentee makes a product outside of Korea, then sells it to a domestic importer, then the act of import does not infringe upon domestically registered patent of the product. That is useful for not only a product, but also a method invention as well. So if defendant legally purchased their product, then this defense may be the right option to use. Then let's move on to the next topic, which is patent invalidation trial. As I said before, patent invalidation trial is overseen by IPTAB. While this trial by IPTAB is not legally binding to district court, they usually give deference to IPTAB's decision because of their exclusive jurisdiction and technical expertise they possess. So if both infringement litigation and invalidation trial are simultaneously ongoing, district court usually wants to hear IPTAB's decision before making their judgments. However, this does not mean that the district court always wait for IPTAB's decision. It is not mandatory. So in practice though, IPTAB's trial decisions come out faster because IPTAB's schedule is usually fast. And as I said, IPTAB's decision is not legally binding, but district court gives deference to IPTAB's decision. So filing for this trial shifts focus suit from infringement to invalidity. Also, during the invalidation trial, plaintiffs usually narrow their claims, which is often beneficial to defendants. Furthermore, defendant in the infringement litigation can argue that plaintiff's request to produce evidence should be denied as impractical and unreasonable because of invalidity. As you can see, patent invalidation trial is useful for defendants in patent infringement litigation. So we strongly recommend defendant to file for invalidation trial. Practically speaking, defendants need to promptly initiate prior art search when sued for patent infringement. Well, lastly, I want to briefly touch on counterclaim measures. Because IPTAB has exclusive right to invalidate patent, defendant cannot counterclaim in the district court to invalidate patent. But other types of counterclaims can be used to press plaintiff. First, if defendant can reasonably argue that there is no infringement, yet plaintiff still petitions for preservation of evidence order, defendant can counterclaim for compensation of damage for unjust filing of the petition. Another counterclaim is possible for business obstruction when plaintiff publicly slanders defendant with bad intention. For example, saying that defendant is infringing on plaintiff's patent right on press, or if they send warning letter to defendant or defendant's clients that defendant is infringing. This counterclaim would be also stronger if defendant can argue that there is no actual infringement. So That's it, and thank you very much for your time and listening to my presentation today. If you have any questions or comments, I will be happy to discuss further. Thank you.
Thank you, Mr. Clark. Hello， 先生把门开一下，信号不好。Thank you, Mr. Clark. Very accurate in seconds. Next jurisdiction will be China. The China panel will have two excellent lawyers. They give me a very long CV. I have to make it very short. So our first one is Mr. Wu Xiurong. Mr. Wu, can you hear me? Yeah. Mr. Wu is the head of IP department of King Kong Law Firm. He is distinguished international lawyer of All China Bar Association, a nominee of Great IP Lawyer by Guangzhou Bar Association. He is a lawyer and patent agent. Is also an arbitrator in some arbitration commissions. Mr. Wu has practiced in IP for over 20 years, has represented thousands of cases in infringement litigation, prosecution of patents, and arbitration. Mr. Wu has a master's degree from Max Planck Institute of Innovation and Competition in Germany and the George Washington University. He has also obtained MBA and bachelor degree in China. The other speaker is Mr. Yi Wen, Mr. Wen Yi. Mr. Yi, yeah, Mr. Wen is a lawyer, patent agent, arbitrator, national patent information teacher. He's also executive director of South China Intellectual Property Arbitration Court. He has been selected as an expert of Guangdong Province Geographic Indication Expert Database, a special expert of Shenzhen People's Media Training Base. Mr. Wen has focused on providing professional services in the fields of patent application, patent analysis, IP litigation, technology transformation, product investment and financing. He also authored a lot of articles and books. Who will start? Mr. Wen. 文艺是你先开始吗? Okay, you may start the slide, Mr. Wen and Mr. Wu. Please. Just a moment.
Hello? Hello? Okay. This part is
Okay, good.
into the two introduction. The first part is for me to introduction. Next, I will talk about the patent infringement defense in sixth part. The Chinese law is somewhat similar to other similar laws.
Show me slides. 把你的 PPT 打开 Show your slide.
Show you.
That's good. Okay.
Okay.
Not okay. Back to the panel. Open your PPT. Please open your PPT again.
Wu 律师能打开吗?
Yeah, I'm trying, but yeah, it isn't working.
I think you may continue.
Hi, this is Rhonda. I can.
Okay, how about Rhonda,
Okay, Rhonda
I
will
can-
help us. Rhonda will help us.
Hi, I can share my screen and you can just tell me when to move to the next slide.
Yeah, let's do that.
Okay.
Go ahead.
Thank you, Rhonda. Please.
the last one.
Can you see the
Yes.
PPT?
And you may continue, Mr. Wen. Rhonda, this
Okay.
is right. Wenyi and Roger Xiurongwu PPT. Yes.
Okay.
Rhonda, please.
This part is divided into the two introduction. The first part is for me to introduction. Next one, I will talk about the patent infringement defense in 6 part. The Chinese law is somewhat similar to other civil law system. First of all, the patent invalidity defense. The so-called patent invalidity defense is focused on the validity of the other party's patent right. Attack the patent right based on the other party directly. Patent professional can be sent to investigate to the legal state of the patent involved, judge whether the patent had been altered or not, had it been terminal or not, it is invalid or not. If it determines that the patent involved had been invalidated, we can file the patent invalidation request with the Patent Re-Examination Board. 2. No infringement defense. No infringement defense is to claim that Sue technology solution does not fall into the scope of the patent protection, which means there is a fundamental difference between the accused infringement product and the patent technology solution. Especially, there are 2 cases. The first, comparing with all technology features recorded in the claim, the technology feature of the Sue infringement technology solution lack 1 or more technology feature recorded in the claim. Second, compared with the corresponding technology feature in the claim, 1 or more of the technology features of the Sue infringement technology solution are neither the same or equivalent. 3, existing technology defense and existing defense.
Mr. Wu, I think
The scope
Mr.
of
Wen
the protection of the patent right involved in the case with the technology feature of the accused infringement product. It is controlled whether the accused infringed product falls into the scope of the protection of the patent right involved in the case, and all the technology feature of the accused infringed product fall into scope of the protect of the patent right. Then, comparing all the technology feature fall into the scope of the patent protector with technical feature of existing. Now, if the accused infringed technology is complete, consistent with the existing technology, then existing technology defense established. If there is difference between the accused infringed technology and the existing technology, and the different can be directly replaced by the common means or can be identified as the common knowledge in the technology field. Then the existing technology defense can be established. 4. The legal source defense. Legal source defense should be including the following element. The first, the purpose of the responder behavior is production and operation. Second, the subject of the defense is limited to actors of use, process, or sell to sell, not including behavior, the production, manufacturing, import, or export. Third, subjective, the nature of adverse must be good faith. Fourth, defender need proves legal source of the infringing product. Fifth, defender of the condition to know. 5. No stop infringe defense. When the accused infringe consider infringing of the patent right, but the order to stop the infringement will damage the national interest of public interest, the court should not order to stop the infringement. 6. Affirmation of no tort. The affirmation of the no tort of the patent right refer to a kind of the litigation type in which accused infringing requests the court to confirm his behavior does not constitute infringement, and in order to clarify the legal relations and emulation the dangerous and unstable state. When the suspected infringing received the notice the infringing in the various unsuspected no force from the obligee, it aims to prevent the patent right holder from the abusing their right. There is 3 conditions for the fall of no tort, the case of the patent right. First of all, obligees ensure a warmer of the infringing. Second, the opposite part of the right did not recognize the infringing and put forward a written notice. Third, obligee do not withdraw the warming with Norbert Pierre's right and did not. Okay, that's all.
Mr. Wu, I think it's your turn. Mr. Wu.
Everybody, let's just make this comment here. You. And I have 2 points to speak. My countermeasures focus on competition law because my slides cannot be uploaded, so I sent some messages by the messengers. Okay, I hope you can see it. Okay, so the first point is the first countermeasure is antitrust law. Like my German associate said, yeah, if the patent is a standard essential patent, and if suppose the company A, the German company, has used this patent for some red things such as overpricing, this kind of things, okay, and company A's behavior is considered as violation of the antitrust law in China. So for company B, it can ask for fair patent licensing. And if company A refuses to grant licensing to company B, then company B can sue company A for a violation of antitrust law. And another point is, suppose if company A is an international company, so yeah, it happens quite often. And because competition law is the jurisdiction of company law is not similar to the civil cases. For most of the civil cases, for example, Chinese courts have jurisdiction to company A, even if it's a German company, and even if its acts are in Germany or in the US outside of China. And the Chinese courts have jurisdiction over company A's behaviors if these behaviors has some bad impact over Chinese competition, Chinese economy. So in this context, company B can use competition law as an leverage and to talk with company A. If you sue me patent infringement in China, and then we can make complaint with you against you in the EU, and inciting TFEU 102, and also we can also complain you with US DOJ, the Department of Justice, or ITC, International Trade Commission. These two organizations are in charge of unfair competition law. So by this means, company B get leverage. And we have practiced this way, and this is very effective, particularly to some big companies in Europe or in the US. So this is first one, countermeasure, antitrust law. Countermeasure are separate too. They are collectively called competition law in some other jurisdictions. And in past years, I have read a case, and in this case, the plaintiff sued the defendant with a patent, which is obviously lack of novelty. And the plaintiff sued company B actually for, just do something bad to his competitors. So in this case, the plaintiff actually was against unfair competition law in China. So in this case, suppose company A, for example, steals company B's technologies and then applied patents with these stolen technologies. And then company B sued company A sued company B for patent infringement in China. So this is, I think, can be considered as unfairly competing with company B. So I think these two ways are quite new, but are very effective. Sorry, Mr. Pan?
Okay. Thank you, Mr. Wu and Mr. Wen. Everybody back? Yeah. Then we have the last jurisdiction, Mr. Ma, Mr. Ma have not given me any of your CV, but I think you can introduce yourself. Over the very short time, can you finish this in 5 hours, 6 minutes? Thanks a lot.
Hi,
Mr.
Mr.
Ma,
Pan.
please.
Thank you all. It's a great honor to be here. I'm sorry I didn't realize I didn't send you the CV. So let me just start and go forward and speed up a little bit. And first of all, good morning to everyone. As you can see, the sun is coming up here in Sao Paulo, so it's quite early. I know it's afternoon, it's late afternoon for some of you. So thank you, IPBA, Jack Lee, Honda, Mr. Pan, yourself, fellow panelists, and most of all, each and every one of you who is here today. Well, since we're lawyers, let me start with a disclaimer and an introduction. Now, I'm not an IP lawyer. I'm not a litigation lawyer. I'm a corporate M&A lawyer. I have close to 20 years of assisting foreign investors in between Brazil and China. And as such, we have faced a lot of different types of issues between Brazil and China, including IP matters, both for patent and trademark violations. And in fact, we are having one telecom patent violation claim, very similar to the case you said, just involving US, China, and Brazil ongoing. And this disclaimer also allowed me to thanks for and give credit to Stephanie Shiver from IP practice and Sophia Lima from our litigation practice. Like in other jurisdictions, Brazil has a specific industrial property law, and it's a party to several international treaties such as Paris Convention and TRIPS. Like in other jurisdictions, protections granted to patents in Brazil are limited to the Brazilian territory. Now, before we move to the legal options that we divided in administrative and judicial levels, and most likely trying to engage a technical expert, my suggestion is go ahead and have a good and sometimes long meeting with your client. Usually, they have already faced a similar issue with that specific patent or element before, maybe in this jurisdiction or other jurisdictions. They are aware exactly what the similarity elements are. They know exactly what the point is. And most of all, they have a good sense of the implications, both technologically and business-wise. Just to give you an example, when you talk about TV and computer monitors, nowadays it's very clear that we use LCD monitors, and this is the mainstream. But if you go 15 years ago, when CRT, the tube monitors, was mainstream, and you had a CRT monitor patent violation, we might think it's a big issue. But your client might just say, I don't care about it because that's the past. We're looking to the future, which is LCD monitors. And the same might happen today. When we talk about batteries, just and say, oh, lithium batteries patent is a big thing. And your client might just say, oh, this is old thing. We're looking into graphene batteries or solid state batteries. Business-wise, this is something very important. Your client might just tell that patent violation, that patent is used in our most profitable line of product, or it might just tell it is used at the least profitable line of product, and we're already thinking about discontinuing. So this information will help you set a strategy for your client, and draw that free line and balance between, legal protection and commercial needs. Now, once you draw that that line, then you'd be able to move to the legal options. And we're not that different from the other jurisdictions, at the administrative level, when we're talking about going to the patent and trademark office. Brazil has a patent and trademark office. Now you can go over to that body, and try to challenge the patents that they have, based on lack of innovation, innovative activity, or of industrial application. Now, with the patent of the company A, is still being filed application, is still on application, you can file oppositions, subsidizing the challenges. If the patent has been granted, you can file administrative invalidity proceeding within 6 months from that patent being granted. Now, if it's over, then your only recourse is going to the litigation levels, and it's going to the courts. Now, the Brazilian industrial property law just state that the jurisdiction for the invalidity action, is the federal courts in Brazil. There's also an option here in Brazil that you request for a negative declaratory lawsuit, which essentially you ask the courts to declare that you have no patent infringement or some declaration into that, and pretty much you're free to go. That's something that's important to mention here is about the jurisdiction into that. Like Brazilian justice, and then specific Brazilian civil procedure code, state that the Brazilian courts, that with the products are manufactured sold in Brazil, the Brazilian court will have jurisdiction into that. So we have concurrent competence to deal with that. Even so, you might be having this lawsuit already ongoing in somewhere else. And he also said, in Brazil, and forgive my Latin pronunciation, lis abili pendens, which essentially said, when the discussion is being discussed in somewhere else, in other courts, you shouldn't discuss that. And that doesn't apply to Brazilian court. So even with that, this being discussed in Germany, United States, Japan, Korea, this does not prevent that to be discussed under Brazilian court. So you can bring that into Brazilian court. So this would sum up and give up your possibility to set a strategy, for your client. And just to give example on the case that we're saying we're facing now, involving China, US, and Brazil, our client is so sure that there's no patent violation, and by the end of the trial, they're gonna be deemed, at this no infringement to the patent, that they're not focused on the discussion on the merit, they're just focused on the preventing preliminary injunction. That was the sole work that we did, so that the court doesn't give any preliminary injunctions before checking the merits of that. So that's, and preventing the client to produce and sell in Brazil. So this is the overall sum. It's not much different from the other jurisdictions. But again, as I said, talking to your clients, they usually have a very good sense and how to do and if that's an infringement or not. And I hope I summarize and speed it up enough to fit in our time, Mr. Pan. So I hand it back to you.
Thank you, Mr. Ma. That's very good summary. But we have not finished yet. Rhonda, can we have 10 minutes for Q&A?
Yeah, you can have as much time as you would like. So please continue.
Okay. I just checked the Q&A. I found one question online. Everybody can see the question on the top of your Q&A signal. Any jurisdiction want to answer the question briefly?
Yeah, may I take a lead?
He seems asked to all the panel.
Mr. Brown, can I answer as to the Japan jurisdiction to the question?
Yes, please, Masa.
Thank you.
Yes.
So the question number one is, in Japan, it is called a prior user's right. So if the defendant has implemented or in the process of the preparation of business implementing the patented invention, the defendant can say that he or she has a prior user right and can seek a dismissal of patented claim. But the scope of the prior user's right is limited to the scope of implementation that the defendant actually did at the timing of filing of the patent application. So and it is difficult to establish the fact of implementation because the defendant needs to have a precise date of his business of implementation. So although it is difficult, but there is a possibility of such a defense. And as to the question two, it is about the effect of.
Sorry,
Yes.
Masa. Rhonda just reminded me that the audience cannot see the question, so I need briefly introduce the question. Question one is, if the
maybe
defendant.
Let's stick to question one first. Maybe it's completely different question.
Okay. Let me finish the question. If the defendant has manufactured the same products by the same technical or made necessary preparation for manufacturing before the patent application date, did the defendant infringe the patent rights? How could the defendant prove the non-infringement under such circumstances? Evidence and proofs to be submitted. That's question one. Question two is if the two parties reach the agreement under the mediation of the court, but the defendant fails to fulfill the obligation, could the plaintiff file the case to the court again? Are there any differences under various jurisdictions? Masa, please continue.
Actually, I have answered question number one. And as Andreas suggested, I think we can first focus on the question number one. Thank you.
Okay.
Yeah, okay. May I say something on Germany?
Yes, please.
Question one. Actually, it appears that here the situation is quite similar in Germany and in Japan. As the other speaker already said, if the defendant has really used the technology and the invention in his own business, in his own factory, then this would be a defense, and he would not be held liable. There could be no infringement. The problem is that, on the one hand, this will be interpreted, very narrowly. It will be a very strict test and not a wide, expansive concept. And also, of course, you would have to have really convincing evidence. You need, I think the question was asking what kind of evidence, and here I think you need a lot of evidence, and you need documentation, certainly. You would have to have documentation, but also witnesses to confirm. So it will be a strict test. But on principle, if you can show that the invention has been used in the enterprise, in the business, then it is a valid defense in Germany. Thank you.
Okay. What about US, China, and Korea? Anybody want to say something briefly?
Let me say something in perspective of Korea litigation system. So, as Japanese speaker and German speaker said, the simple answer is no, because patent can have a right after registration. But the relevant question is what happened? What happened if the defendant has manufactured the same product before the patent registration, but after the patent application? It is a very interesting question. Regarding that, in this regards, Korean patent law regulates some situation. So I'd like to share this with everyone. A patent applicant may claim some compensation equivalent to an amount to which he or she is ordinarily entitled to for practicing the patented invention from a person who has practiced for business purposes the invention claim in the patent application after receipt of a written warning given under this situation. So the patentee, the patent owner, can claim some compensation equivalent to some royalty when he gets the patent registration. So that's it for my comments. So question number one.
Thank you, Mr. Koch. Chris?
Yeah, in the interest of time, I won't speak long, but the situation is similar to what Masa and Andreas described for Japan and Germany. In the US, there would be a valid defense, assuming you had sufficient evidence to establish your prior practice of the product. But yeah, the circumstances are basically the same in the US.
Mr. Wu, you want to say something?
I want to take the question because I just had one case litigation about the first question. So if the defendant had used the technology before the filing date of the patent, so by Chinese law, it's definitely no infringement. But for the defendant, it cannot use the technologies beyond the scope of what it used to make the product. For example, the sales channel or for channel. If company B used a new channel to sell the infringed product, then company B might be considered as infringement. But if everything is just as what what it was, then no patent infringement. And the second question is quite interesting. If the two parties make settle the case and sign the agreement, but one party failed to fulfill the agreement, so yeah, it's quite controversy. And I think the breaching party, yeah, may be sued for breach of contract. Yeah, Mr. Pan.
Okay, thank you, Mr. Wu. I think I have a very simple question. I think many audience may have interest. In Chris' presentation, you mentioned about the potential stay of the court litigation pending IPR. My question is, you mentioned that in the United States, the state court of Texas, California, and Delaware may have potential stay. For other courts, they usually proceed for the IPR proceedings. So any other jurisdiction, or first to Chris, any other federal court, our state court, they usually don't stay when we have the IPR. And for other jurisdiction, if you have a litigation of the intellectual property litigation in the court, that the court usually stay, or they need to stay only depending on some special conditions or terms or conditions. Chris?
Sure. Well, for the US, the stay is not mandatory. So it's up to the discretion of each individual judge. And so I was saying, as a general matter, the judges in federal district court in Delaware, for example, and California, tend to issue stays of the litigation pending the USPTO review of the patent. The judges in Texas, not all the judges, but I would say the majority of the federal judges in Texas, whether it be the Eastern District of Texas or the Western District of Texas, those are where all of the patent cases tend to be filed. Those judges will generally not grant stays of the litigation and force the parties to proceed with the litigation, even when the patent office is conducting a review of the asserted patent.
And that's why many IP owners prefer to file IP litigation in the Eastern District of Texas Federal Court, right?
Correct. That and other reasons, primarily being the juries there tend to give big plaintiffs awards, so hundreds of millions of dollars. So that's another reason why they like Texas. Okay,
I want to check the question to one by one. Germany, Japan, Korea, China. Please, Andres. Andres?
Are we with question 2 or?
Question of the potential stay, or whether the court will stay of the IP litigation when we have the invalidation proceedings.
Yeah. Okay. Thank you. Okay. Well, as I mentioned in my talk at the beginning, we have the separate system. You have to bring invalidation claims in another court, in the federal court, and while the infringement proceeding will be in the state court. It is actually the case that the courts in the infringement proceeding are reluctant to stay. Sometimes, if you have a very convincing case, if you produce your invalidity arguments very convincingly, you may be able to get a stay, but in most cases, the courts would not stay the proceedings.
Okay, thank you. What about Japan?
Japanese court, so it is not stay is not mandatory. So it's up to the judge's discretion. And usually judges do not want to wait or informally stay the infringement procedure. But if the judges learn that the invalidation trial decision would come from the JPO soon, the judges may want to read the JPO's decision. So the judges may put additional court hearing date so that the judges can have a chance to read the JPO's decision. That's in practice.
But
in
how
Japan.
the judge can make a guess whether the GPO will issue the invalidation decision on what time frame?
Yeah, usually judges frequently ask the parties about as to the progress of the JPO's procedure, and the judges can also ask an progress directly to the JPO.
Okay, thank you. What about Korea? Hello, Mr. Kwok.
Oh my, can you hear me?
Yes.
Okay, as I mentioned during my session, yeah, such as Germany and Japan, it is not mandatory. So it does not mean the district court always wait for IPTAP's decision, but in practice, district court usually wants to hear IPTAP's decision before making their judgment, because district court judges think IPTAP has more expertise in patent matter. But interesting thing is, in practice, IPTAP's trial goes faster. So in most of the case, district court can see the result from IPTAP trial decision. And this is a practice in Korean litigation for patent matter.
Okay, thank you, Mr. Kwok. And Mr. Wu, maybe you can introduce why the Chinese courts IP litigation need to stay when you have an invalidation procedure.
Okay, so by Chinese patent law, and yeah, if you just look at law, it's not doesn't say a judge must stay the proceedings or not, but in practice, normally a judge normally, yeah, is very reluctant to stay the proceedings because IP judges are quite busy, and almost in almost every important patent litigations, the defendant always invalidate the patent. So if a case is stayed, and then it wastes time. So just like most jurisdictions, yeah, it's fine.
Okay, thank you, Mr. Wu. Hello, Rhonda. I think we almost run out of time. At least we have very interesting question, except some jurisdiction, some states in US, we do not need, we do not have a mandatory stay by the courts in the IP litigation, even the defendant file on invalidation proceedings. So I don't think we have time to answer some more question. So Rhonda.
Hi, yes, hi.
Yeah, if audience have more question, how can they approach to the speakers or to IPBA?
Oh, actually, yeah, they can send me an email. That would be no problem to send me an email to IPBA@ipba.org. And then I can forward it to the speakers.
Thanks, Rhonda. Finally, we see your face. That's very important.
Sure.
So, dear audience, do remember we have IP expert, patent expert in our IPBA group. If you have any question, do remember send it to any of us. I will send it to Rhonda, with the only lady in this screen. So, thanks all the audience. Thanks all the speakers. We appreciate. We are really looking forward more online webinar. In the coming IPBA annual conference in Shanghai. So most probably we will be online. And in addition to the IPBA annual conference, we may organize some other webinar. This time, this webinar is so technical. I mean, it's an invention patent, but we will organize more IP discussion on trademark, on copyright, which we believe more audience or more of your colleagues will have interest. So thanks a lot. Thanks, Rhonda, and thank you, everybody. Thanks all the speakers. Thank you.
Thank you very much.
Thank you very much.
Thank you.
Thank you.
Thank
Happy
you.
New Year.
Thank you, guys.
Once again.
Sorry for the
Bye-bye.
technical issues. Thanks.
See you in Shanghai.
Thank you.
Bye-bye.
See you.
See you
Take
in
care.
Shanghai, everybody.
Bye-bye.
Bye.
Bye.